In preparing for this panel, I've been continually forced to revise plans for it, and I'm going to revise them at the last moment once again. I had planned to make some introductory remarks prior to launching into a questioning of Senator Specter, but because Senator Specter will be with us only for another 15 or 20 minutes, I think I'm going to abort that. We'll come back to it later. After Senator Specter leaves, the members of the panel will have an opportunity each for a few minutes to explain the legal issues and investigative issues of concern to them, and we'll follow that with a debate of those issues. But I think now, because we have a rare opportunity to ask Senator Specter some direct questions, we'll cut to the chase immediately and go straight to the single bullet theory, which this morning Senator Specter has elevated to the single bullet fact on the basis of a television docudrama presented by a TV network that, appropriately enough, is owned by a cartoon company. Senator Specter, if I'm going to ask you to imagine that there's a real trial of Lee Harvey Oswald going on, and you have to prove the single bullet theory. And so I want to go through some of the elements. The first problem I think you would have, maybe Bob Tannenbaum, who was a former prosecutor, could tell me, but I think your first problem is you got to get the bullet in evidence. Bob, could he do that?
Well, you have a chain of custody issue. As I understand the evidence,
you get to the microphone.
As I understand the evidence with respect to admissibility of a chain of custody issue and an identification issue from the individual who found the bullet was a hospital engineer, as I recall, found the bullet on a stretcher that had nothing, that was not associated with either Governor Connolly or with the president. And that individual, when shown the bullet thereafter, did not identify it positively to the FBI as the bullet that he found. So on that basis, I think you'd have a serious problem in admissibility.
Senator Specter, would you agree?
The individual was a man named Jimison, and I have not re-reviewed the record. And I questioned him on a deposition in Dallas in the spring of 1964. And I had an FBI report of an interview which they had had. And Mr. Jimison deviated from what I had expected his testimony to be based on the report. And I was delicate with him in not leading him. And I invite anybody to read the record of my questioning of Jimison. I was well aware of the fact that people would look at it and see what he had said. And I was extremely careful not to lead him, to let him speak for himself, as I did with all the witnesses. And I believe the substance and conclusion was that it came from Connolly's stretcher. But when I made my presentation, I referred to that on several occasions, and I very carefully said the stretcher thought to be Connolly's, because there was some issue based on Jimison's testimony. But I've had some experience with a chain of evidence, and I've had some experience with trials and murder cases, and I don't think we would have had any problem getting that bullet into evidence on the basis of its established connection to the Mannlicher Carsano rifle. Conclusively came from it, and the identification of that rifle, the strong evidence linking Oswald to the rifle.
Okay, now,
Can I just respond to that for a moment?
yes, Mark Lane, I believe you had requested one time that the Warren Commission permit you to represent Oswald, and they declined, and they appointed an attorney who seldom showed up and didn't ask any questions. Is that correct?
Showed up twice and didn't want to be there. At one occasion, he said nothing. On the other occasion, he made a statement totally unrelated to any representation of Lee Harvey Oswald.
Sounds like Oswald's lawyer was guilty of malpractice.
Well, let me just
yes.
say about that. It's like the irrefutable evidence presented by ABC in a program I haven't heard, but I've just heard them say they had irrefutable evidence. I don't think anybody here who's been studying this for many years was invited to appear on that program. It's irrefutable if you don't allow anyone to refute it. That's what irrefutable evidence is by ABC. And that's what irrefutable evidence was for the Warren Commission. Senator Specter can say he never let a witness read the record and see if you can stop laughing when you hear him say that. You saw it on the screen yesterday when he made up the story to the doctors. If you accept this, accept this, accept that, aren't I right? Okay. I mean, that's not just leading. I've been trying cases for 52 years. I would have been under the jail a long time ago if I ever did that in a federal court with any witness. And they had lawyers like Mr. Specter who led witnesses. They denied the right to another side to raise any questions. It is an investigation, unlike, as I said, the Lincoln investigation just after the war, military tribunal, they had a public hearing.
Okay.
These guys kept everything locked up in secrecy and no one else could be there.
Okay, Senator Specter, my question is, you have to introduce evidence through a witness. Are you seriously contending that you would recall Tomlinson as your witness to introduce the bullet, given
Sure. I think that
subject to impeachment, isn't it?
Sure, that's fine. Let him be impeached.
Okay.
Let the chips fall where they may. Tomlinson was an indispensable witness. When a prosecutor puts on a case, he's obligated to bring on all the eyewitnesses, whether they're with him or against him.
But when the witness says that...
May I finish?
You may.
I would bring Tomlinson on as a witness. When Mr. Lane said he wasn't invited to the ABC program, let me say I wasn't either. They didn't ask me to come on to the ABC program. They were dealing with my single bullet, and they didn't even invite me.
Okay.
When Mr. Lane said everything was a closed arrangement, that's not wholly factual. Mr. Lane got an open hearing when he represented Lee Harvey Oswald's mother.
That's also one of the major lies which has been told regularly. Let me tell you what happened. When the Warren Commission called me because I had raised some questions, called me as a witness, would not allow me to be present at the testimony of any witness. Everything was marked top secret, including my testimony. But I did not know that then. I said I will not testify at a closed hearing. The American people have a right to participate. Our president was killed, for God's sakes. And they said, all right, your hearing can be open. It was the same closed room. The media was outside. They were never told they could come in. No one from the media was ever present. My testimony was marked top secret when I left, and that's what Mr. Specter says is an open public hearing. Maybe it is to him, but not to the rest of us who spend our lives practicing cases in courtrooms with the public always present.
Okay, let me move to the next question that I see. Let's assume, however improbable it may be, that you can get the magic bullet introduced into evidence through a witness who refused to identify it. Your next problem, as I see it, is you've got to place Oswald in the 6th floor window. Who are you going to call to do that?
the co-workers who saw him on the 6th floor,
Did they see him in the window?
palm print, the print which was on...
Well, wait a minute.
Now, may I finish? I'm not going to speak very long. The print which was on the box of the rolling readers, the weapon being the Mannlicher Carsano being found at that window with his palm print and with the record of his having purchased it. Let me just make one brief comment as to what Mr. Lane said. I thought at the time and continue to think that the hearing should have been open. I would have had the hearings open. I would have had all of them open. I think that it would have been very salutary for people to follow the course of the investigation and to have seen the nature of the investigation and the questions which were asked and the way the matter was conducted if people had seen it.
Okay.
And the commission made a contrary conclusion. It was regrettable that I didn't run the commission, but I didn't run the commission.
Let me ask you this. Are you going to call Mr. Bremer to place Mr. Oswald in the window?
I'd have to go back and reread the notes to give you an answer to that.
Well, he was the star witness the Warren Commission was, too. He's the guy that says Oswald was in the window.
Well, I'll just have to repeat, I'd have to go back and reread the notes to give you an answer.
He was the sole witness. He also was almost blind. He didn't have his glasses on that day, which is one of the reasons Mr. Specter probably doesn't remember it anymore.
In addition,
And I'd like to make one point, if I can. They found the Mannlicher Carsano, Italian weapon, there at the window. It was found by Seymour Weitzman, former Dallas police officer. He was a police officer at that time. And he described it in a sworn statement as a 7.65 German Mauser. It's his sworn statement. What Mr. Specter and the Warren Commission said, he wasn't really familiar with weapons. He was a deputy sheriff, and he owned a shop where he sold rifles. And he is holding in his hand a weapon, which he says in a sworn statement that day is the weapon he found, a German Mauser 7.65. I've held the Mannlicher Carsano, this one that they claimed was Oswald. I held him in my hand in the National Archives. It couldn't be clearer. 6.5. There is no mistaking that with a German Mauser. So I think one would have a big problem getting the weapon in, depending on which one you want to use. If you want to use the one that Seymour Weitzman said, that's okay, but then you don't have a match to the bullet. If you want to use the one which they came up with later, then you have to explain why Seymour Weitzman said, that's not the weapon we found. And nobody saw him on the 6th floor among his co-workers at that time, and the only eyewitness was Mr. Brennan, who had very severe eye problems, and we traced back his doctor. The Warren Commission didn't do anything like that, and he could tell you how tall the man was. He's looking up 6 stories, and half of the body is cut off at that angle. He could describe his height.
Yeah.
Pretty amazing testimony.
Senator Specter, did you look at the Zapruder film to determine whether or not Mr. Brennan was actually looking at the window at the time the shot was fired?
I don't believe the Zapruder film shed any light on that subject.
Well, Professor David Rohn, who is here, has written a book on the Zapruder film, and he says the Zapruder film shows that he was not looking at the window. Don't have it ready.
The Zapruder film, which I examined, as I've already said, under a microscope, involved the sequence where President Kennedy and the motorcade came down, obscured by the sign for a time, but that was the part that I had examined.
Okay, let me move on to what I think is your next problem. You're arguing that this bullet that inflicted 7 non-fatal wounds on President Kennedy and Governor Connally, going through Kennedy's back, you say neck, exiting, going through, hitting Governor Connolly, smashing 5 inches of his fifth rib, exiting his chest, and diving down into his thigh without losing any appreciable amount of material. You say this is the bullet that was fired from the 6th floor. Don't you have an angle problem? And before you answer, I want to hear Bob Tannenbaum. Does he have an angle problem? Lateral or vertical?
Part of what the problem is for the prosecution is some of the issues that are raised both by Senator Specter and Mark Lane. That is to say, when Senator Specter says there was a print, yes, Senator Specter is correct. There was a print. The only problem is that when the rifle was first dusted, allegedly partial prints were found, but they weren't photographed. The FBI took that rifle, went back to Washington. It was processed by the head of the department, who is a world-renowned expert. And I had occasion to use him on, as a matter of fact, on cases, and that department, particularly on cases when I was in the Homicide Bureau in the DA's office in New York County. And they found, when they dusted the rifle in Washington, that it wasn't even processed, much less any prints of value. Thereafter, a print was found. But again, with respect to the presentation of the case in the prosecution, it does create a serious exculpatory issue. Similarly, as when I was involved with the committee, we had occasion to, of course, go through the trajectory. That is to say, the direction of the rifle as it pointed from the so-called sniper's nest. And what was clear and very plain was that the trajectory was from a right to left angle. That is to say, as the motorcade passed by, in the fixed position, the shooter, as the Warren Commission held, Lee Harvey Oswald, or anyone shooting from that window, in a fixed position, had a right to left angle that the bullet would have passed through the president. And of course, that creates a problem with respect to the alignment of the president and Governor Connolly, who was sitting directly, of course, in front of the president. So it makes it even more difficult to have that kind of injury occur as described, not to even get into the issues that the senator raised during his presentation with respect to the pristine nature of that bullet, and given the notion that all the tests that were conducted both by the Warren Commission and by the House Committee, just one shot into the wrist, into a cadaver, caused the bullet to be substantially impaired.
Okay. Senator Specter, you say that...
Excuse me, sir. I hate to interrupt. We have to keep to a schedule for upstairs. So I'll let the senator answer if he has time, but we're behind schedule right now. I apologize to the audience.
Oh, I want to take time to answer that. There was no alignment problem. The president was seated slightly higher than the governor, who was in a jump seat, and the governor, as I recollect it, was slightly to the left, and the bullet which exited from the president's throat and nicked his thigh had to go somewhere. There was no mark inside the presidential limousine. It exited from the president at a very high velocity. The tests were conclusive on that, and the governor was right in front of him. And there's no place else that the bullet could have gone. And the trajectory was lined up. When we had the on-site test, we had a simulated president, the simulated governor, the car, and it all stuck together.
Senator, let me ask who you're going to call as a witness to show that the bullet hit Kennedy in the neck, as you call it, and transited through his throat.
Well, the Zapruder film would be evidence. The medical evidence would be probative.
You're going to call Commander Humes?
If I can finish. They even let witnesses in trials finish, and of course this feels like a trial.
Yeah, but they're not allowed to filibuster.
But I'm I'm not the witness. I seem like I'm the defendant. But when you have a trial, you have juries, and you have juries to decide jury issues. And if somebody can't see too well, they testify, and a defense lawyer, maybe not as erudite as Mr. Lane, but a defense lawyer points out problems of sight, or what Jemison had to testify to. And these are jury questions, and you may be able to raise some questions, and that's up to a jury. And I'm impressed with Mr. Lane's long experience as a trial lawyer. I've had some myself. And my judgment, for whatever it's worth, is that there was a very strong case against Lee Harvey Oswald.
Yeah.
Well, thank you all very much.
If I may, at the risk of having 900 people upset with me, including a United States Senator, we do have to get him upstairs, so I'll take responsibility.
I'd like to comment on the wounds that Governor Connolly suffered. First of all, if you look at the Zapruder film, and you have to remember that the Zapruder film is not a film alone, it's a clock. When you realize that the film went through the Bell and Howell camera at the rate of 18.3 frames per second, you have a clock. You see what's taking place from one moment to the next. When did Governor Connolly react to his injuries? Less than 2 seconds after John Kennedy had been shot. Is that a problem? Well, yes, it's a problem because the weapon which they ended up with, the one we arrived at originally, we don't know, but the one they ended up with, the Italian Mancano, was tested by the best riflemen west of the Mississippi that they could find, the experts, and they said to work the round into the bolt. It's a hand-operated, bolt-operated organization. To do that and fire without even aiming, it took 2.3 seconds. That's the absolute minimum. How could Governor Connolly be shot less than 2 seconds after the president was, if that was the only weapon? It's impossible. How did the Warren Commission deal with it? This is what they said. And we heard some of this, I think, from Dr. Baden yesterday, that he didn't react at once. As the Warren Commission said, and remember what this bullet did. It entered his back, it fragmented his fifth right rib, lateral and posterior, caused it to become secondary fragments, missiles, which exited from his chest with a large wound which almost killed him, struck his wrist and struck his thigh. The Warren Commission said, there's a quote, he probably didn't notice it because it was, quote, a glancing blow. As Governor Connolly said, I noticed it. And he reacted to it. And that was less than 2 seconds later. The other problem with the magic bullet theory is that at least 5 shots were fired. We can demonstrate that without any question. A bullet hit the president in the back. You saw the autopsy descriptive sheet. And as Cyril Wecht said, he later said they had to correct it by 6 inches. I remember Cyril Wecht, the first time I discussed that with him back in the 60s. He said, you know, it's not 6 inches on the side of a barn. It's 6 inches on a human being's back. I mean, you can't make that mistake. So it was almost 6 inches below his back, below his shoulder on his back. Another bullet hit him in the throat from the front. Every single doctor at the Parkland Memorial Hospital, before Arlen Specter got there to work his magic in his non-leading fashion, before he did that, every single doctor, list them, Kemp, Clark, all of them, said the wound in the throat was a small, neat wound of entrance. We see bullet wounds every day here in Dallas. We know the difference. I know the difference too. I'm not an expert. I fired a weapon during World War II. You hit with a rifle. You hit a tree in the front. It's a tiny little hole. You can barely find where it went in. Turn around to the back of it. That much of it has been ripped out. Exit wounds are different from entrance wounds on trees and on people, and every doctor in the Parkland Hospital said that was an entrance wound. So that's 3. A bullet hit him in the head from the front and killed him and drove him backward. And in addition to that, a bullet missed and struck the curb and splattered up and injured a man named James Tague. At least 5 shots, using the clock of the Zapruder film, in 5.6 seconds, 5 shots. Don't have to be a mathematician. You can't get off 5 shots in 5.6 seconds with a weapon which requires at a minimum of 2.3 seconds as intervals. Can't be done. And how would they explain that? Well, they generally don't even come here to try, and then when they come, they leave early. So we'll never get an explanation, I'm sure. But the fact is that what they set up was a solution to a bigger problem. They began with the presumption that Oswald did it alone. Read the New York Times in January 1964, J. Lee Rankin, General Counsel, explaining how we are going to conduct this investigation. Every panel will have a senior lawyer and an assistant lawyer, etc. And he lists the panels. And they were, what did Oswald do on November 22nd? Oswald's background, Oswald in the Soviet Union, the Marine Corps, Ruby killing Oswald, Ruby's background, and what efforts were made to protect the president. He said, all of the evidence which comes to us will come through those panels. When I appeared before the commission, I said, you might have thought about a 7th panel. Something like, who killed President Kennedy? Because just imagine 3 people came up to the Warren Commission offices and said, listen, remorse is gnawing at us. We killed the president. We want to confess. And the receptionist would look like, I'm sorry, there's nobody here to take your statement. Because it was set up. Panel number 1, what did Lee Harvey Oswald do on November 22nd, is the panel through which they were going to solve all of the questions, because they started with the presumption that Oswald did it alone. Talk to the lawyers who are more honest, who still talk about those things. They were in a state of panic when they discovered the impossibility of 5 shots being fired in that period of time, and they knew it. And they were panicking. They didn't know what to do. Read the report of Earl Warren, secret for all of these years, but now available, where he told this group, truth is not our objective. 100 million Americans might die. The stakes are so high. He was saying we have to do something. And they invented the magic bullet theory. And
Magic bullet fact.
The magic bullet fact. And to their shame, they still stand as if what they are talking about is serious. Yeah. That's the absurdity that Voltaire told us that leads to atrocities.
Yeah. For the record, if I'd had a chance to respond to Senator Specter there at the end, I might have said that witnesses are not allowed to filibuster, and secondly, that they can't leave in the middle of the examination. And I was about to pose, I think I did actually enunciate the question as to whether or not he was going to call Commander Humes to testify. Bob, how do you get around not calling Commander Humes?
Well, let me back. Well, unfortunately, Cyril Wecht or even Mike Bodden were not around. I have a long history with Dr. Michael Bodden. When I was in the Homicide Bureau in New York County, as I mentioned, Dr. Bodden was a deputy chief medical examiner in the city of New York. And in Manhattan, we had about 2 homicides a day. So when you visit New York, make sure you have, you look to your left and your right, and you have someone in front of you and back of you. But Mike then became chief medical examiner in the city of New York, and he was wrongfully removed, and I represented him in a civil rights case, and I tried the case for 12 weeks. So I know Mike, and I am responsible for appointing Dr. Michael Bodden to the committee, and told him only other doctor that I wanted to make sure he brought on was Dr. Cyril Wecht. And then I told him to appoint the best forensic pathologist in the country so that we would have this group together who would go over all the evidence. The problem that I have with my dear friend and former client opinion is the provenance of the material that he looks at. I know Dr. Michael Bottom to be an extraordinary human being, an honest man of high integrity and a brilliant pathologist. I question whether or not what he looks at is accurate. The reason I do that is, it's one thing for a devotee like Mellen, who is no longer with us, or Senator Specter, to constantly simply repeat that there's strong evidence. That doesn't make it so, obviously. That has the impact of a feather when you go through an analysis of what the evidence is. And a prosecutor has an important duty, not to just slop on any evidence they have that comes from the police or otherwise and say to the jury, guess what, it's your turn, decide whether or not it's trustworthy. That's not what DAs do. What they do is they analyze the evidence. They make a determination whether or not someone's telling the truth based upon the totality of the circumstances and whether or not it's corroborated. And where in this case, for example, I hear Senator Specter say there was a small bullet wound in the back of the president's head. What head is he looking at? How do you judge credibility? Were all the doctors and nurses at Parkland Hospital, who had no motive to do anything other than report their observations, were they lying? Were they honestly mistaken? Or were they telling the truth as they saw it? Because if they're telling the truth, in an excess of 25 people, the president had a large gaping hole in the back of his head. And if he had a large gaping hole in the back of his head and the front of his face was intact, how does that square with a shot in the back of his head? When his entire head and body ferociously move backward. This is the defense of where you actually, in New York, when we talked about a motion picture case, it was when we had actual fingerprints, we had eyewitnesses, we had a confession. That's what we called a motion picture case. In LA, they call a motion picture case when they have a motion picture. And the defense says, don't believe your lying eyes. Listen to what I tell you actually is depicted on the film. But that's this case, isn't it? How do you have the law of physics denied very coldly, in a calculated fashion, simply say the head went backwards, he was shot in the back of the head? There was a small opening in the back of his head. When all the doctors and nurses in the emergency unit in the operating room saw a gaping hole. And they made a diagram to that effect, and they signed off on an affidavit to that effect. How do you handle that kind of evidence? How do you handle evidence where you're offering fingerprints and you have a police officer say he dusted a weapon and process it? What does that mean? You put down the magic dust, you see if there's a print, you photograph it first before you lift it. Why? Because you may lose it in the lift. So you want to have documented and memorialized that you saw the print. Well, this wasn't done in this case because the person who did it said he had to go to lunch. But the rifle was taken back to Washington, and the chief said the rifle wasn't processed, meaning there was no magic dust thrown down, much less any prints found, and they found no prints. Now, it's one thing to simply say, we have a print, and now I'm going to put on the witness who found the print subsequently. But no prosecutor, certainly not in the tradition of the office that I served in, maybe today, God knows what's going on with some of these cases, maybe today they do it, but it's a violation of any standard of conduct and gross misconduct to simply offer into evidence the print, in this case, without explaining to a jury exactly what went wrong. And it's not the kind of evidence that I, having tried about 200 cases to verdict, would have ever done or permitted anybody in the Homicide Bureau in New York County to ever do. I can assure you of that.
Yep. All right. We could continue with the single bullet case, but our chief witness has gone, and we have a lot of other ground to cover. we have some new material here this afternoon, and so I would like, it's going to require, I think, some video, and so I would like to have Joan Mellen come up and present some of what she has uncovered regarding the trial of Clay Shaw.
Well, I'm here today to talk about the Garrison investigation, and I'll be talking about that this afternoon. What I'd like to do now briefly is to show some documents especially to the people who are not familiar with the Garrison investigation and what happened to Jim Garrison. And I thought, I did not discover these documents myself. They're part of the record. They're available in the National Archives. But I thought they provide a very good narrative of what happened as Jim Garrison tried to uncover the implementation of the conspiracy to kill President Kennedy that occurred in the state of Louisiana. And I'll have to begin by telling a story that is familiar to most people here who know the Garrison story, but you'll forgive me if I want to make sure that everyone knows the context. On the day after the assassination, that was Saturday, a man named Clay Bertrand telephoned a New Orleans attorney named Dean Andrews and asked that he go to Dallas to represent Lee Oswald. Andrews was in Hotel Dieu Hospital with pneumonia. On Sunday morning, he called his own lawyer, a very well-known New Orleans lawyer named Monk Zeldin, and asked that Zeldin go to Dallas in his place. While they were talking, Zeldin said, "This is on Sunday, don't worry about it, your client just got shot." You all know that story. That same Sunday, Andrews telephoned the Secret Service to say he had seen Oswald on 3 occasions. He told the FBI that Clay Bertrand had accompanied Oswald to his office. In the following days, Andrews was interviewed 6 times by the FBI and 3 by the Secret Service. And in each of those interviews, progressively, they tried to undermine his testimony, to suggest that he was mistaken. By December 6th, Andrews conceded to FBI agent Regis Kennedy that Clay Bertrand was, quote, "a figment of my imagination." By the way, as you're looking at a slide that the last signature there is, of course, Clay Bertrand. So you're looking at the VIP register at the Eastern Airlines terminal at the New Orleans airport. At the Clay Shaw trial, Regis Kennedy, the FBI agent, admitted under oath that the Bureau had been looking for Clay Bertrand even before Andrews informed them about Bertrand's phone call. That the Bureau knew of Shaw emerges, and this explains Ramsey Clark's statement to the press on March 2nd, which was the day after Clay Shaw was arrested, that Shaw had been investigated, a statement that the Bureau later retracted. Clark's information that the Bureau knew about Shaw had been given to him personally that morning by the FBI's Partha Deloach, Deke, referred to this morning by Mark Lane. And Clark told me this himself. When Jim Garrison began his investigation, he at once started looking for this Clay Bertrand, whom he read about in Andrews' testimony before the Warren Commission. A stringer for Life magazine, a former States Item reporter named David Chandler, and a friend of Garrison's was sitting in Garrison's office one day, and David Chandler told Jim Garrison Clay Bertrand had to be Clay Shaw. And I want to say that's important because many people tried to say that Garrison had some grudge against Clay Shaw, and that's why he said that he was Clay Bertrand, but it wasn't the case. David Chandler was his source. Before long, Garrison discovered that the CIA was turning up everywhere in his investigation. He suspected that Shaw was a CIA operative. He didn't have proof yet, and of course he was. And he also suspected that the CIA was not only behind the cover-up of the assassination, that was easy, but also behind the planning, and that planning had occurred, that the cover-up had begun even before the crime. To convict Clay Shaw, he found it necessary to prove first that Shaw was Bertrand, and so involved with Oswald. He needed to prove that Shaw, of course, had knowledge of what was going to happen in Dallas. That's the sine qua non of the conspiracy law. But connecting Shaw to Oswald was a beginning. In November of 1967, a tip came into the office of the District Attorney of Orleans Parish that Clay Bertrand had signed the guest book at the VIP room of Eastern Airlines on December 14, 1966. And that's there's the signature of Clay Bertrand. Look also at the first signature on that list, which is Alfred Moran. I hope it's legible. Garrison then began to interview all the names of people who'd signed the guest book on the same day that Clay Bertrand had. On November 13th, Garrison's top assistant, James Alcock, and a police officer went to interview Alfred J. Moran. Moran identified his own signature, but said, and you're looking now at the Orleans Parish memorandum, the report of Alcock's interview with Moran. Moran identified his own signature and said he did not know anyone else who signed the guest book, including Bertrand. When Alcock asked if he knew Shaw, Moran said that he did, but he had no use for it. He insisted Shaw was not at the airport on December 14th. He would have recalled his presence since he disliked him so much. It turned out, of course, that Alfred Moran was a CIA asset whose office, I believe, was in the International Trade Mart, where Shaw was managing director. And it would emerge that Moran was appalled that CIA had accepted as assets and agents people who were homosexual. This part of Moran's statement to Alcock was true. He hated Shaw. Otherwise, he lied. How do we know that? The next day, I'm also just including the RIF quickly so that you can see that these are the legitimate documents. The next day, November 14th, Moran gave a cocktail party. As a CIA employee, by the way, I wanted to call your attention, researchers, to the testimony of John Whitten, also known as John Celso, before the House Select Committee, and in particular to Whitten's statement that there was really no difference among CIA between an agent and an employee, that you could be an agent and not an employee. So we need that in order to understand what are the roles within the agency of people like Moran and Shaw. Okay. Anyway, at this cocktail party, Moran naturally invited CIA people, since he was one himself. One of the guests was the second person in command at the New Orleans field office of the CIA, whose name was Hunter Leek. And I want to just give a quick flash forward. After the assassination, Hunter Leek said, and he told this to a friendly Louisiana writer, he destroyed all the records of that field office relating to Oswald. Not all. He destroyed many. The rest he personally drove to Langley, Virginia himself. The source of that statement was on this at this conference, and I don't see him here today. Moran took Hunter Leek aside and told him of Alcock's visit. He told Leek that Shaw was there, so he had lied to Alcock, but he didn't make it clear to Leek that what he had told Alcock. He also said, and I think this is the key line at the bottom of paragraph 3, that Garrison had an ironclad case against Shaw. Leek was horrified. He wrote a memo to his superior at the New Orleans field office of the CIA, Lloyd Ray. That Leek misunderstood Moran, and what he told Alcock is reflected in Ray's memo to CIA headquarters of November 15th. Because Moran told Leek that he saw Shaw, Leek assumed incorrectly and told Ray Moran had told Alcock the truth. And this slide reveals that Moran did see Shaw in the Eastern Airlines terminal. The agency had used Clay Shaw for the setting up of Lee Harvey Oswald in the months before the assassination in the state of Louisiana. They were honor-bound to protect him. Hence, there's a frantic flurry of cable traffic and memos emerging once Ray contacts Lawrence Houston. It's a name that you need to know. He's the chief counsel of CIA at the time, in order to inform him of what has happened here, that Garrison has correctly connected Clay Shaw to the Clay Bertrand who telephoned Andrews. And the extent of these efforts, all these documents itself, belies the view that CIA acted so forcefully against Garrison simply because Garrison was embarrassing them. It was much more than that. Frantic, CIA now did a check on Moran. well, I'll go back a minute, and found he was not only with the Domestic Contact Service, he was also an operative. And this document that you're looking at now is the JM Wave response. The JM Wave was the big CIA station in Miami. Most people know that. And it turns out that Moran was so close to the agency that he was a surety. Lawyers know what that means for the CIA field office. The CIA now begins to do damage control and to sanitize its own files so that they can discount the statement that, in fact, Moran has identified Shaw as Bertrand. By November 30th, Lawrence Houston has become actively involved in all of this. And what is he going to do? Well, I don't want to go through all the details, but
Summarize it.
I'm going to summarize it. Maybe you can see that the documents are here. What happened is that Lawrence Houston decides that Hunter Lee should go to Moran and get him to retract his story. And it turns out that they're going on a duck hunt together. So they were very close. And then Moran develops a slip disc. He can't go. And Lawrence Houston suggests that he go to the Lee go to the bedside of Moran to get him to retract the story. Lee goes. Moran retracts the story. Garrison loses a potential witness who could have testified that Shaw was Bertrand. And I think from this story, the point of all of this being that how active CIA was in sabotaging Jim Garrison's investigation from the very beginning, depriving him of witnesses, frightening his witnesses, and really suggesting that they had reason to fear Jim Garrison and what he was finding out about this crime.
Okay, first, Gary Cornwall has handed me a note saying that he had not realized that he was going to be on this panel and that he had made another appointment, and he apologizes for having to leave. I would like to see if Tom Samoluk and Judge Jack Tunheim have any comments that they would like to make before I start in with some questioning.
Well, just let me say welcome to everyone here, and I'm glad to be here. I was fortunate enough to have the privilege to chair the Assassination Records Review Board for the 4 years in which we worked feverishly to declassify the government store of records on the assassination. I'm going to speak about that experience this afternoon. Tom Samoluk, who was a longtime employee of the board, the deputy director for a considerable period of time, and one of our chief analysts is here too this morning, and I want to give him a chance to say a few words.
Thank you, Judge. I want to say that it's a privilege to sit next to Judge Tunheim, who did a incredibly important service to the American public in chairing the Assassination Records Review Board, and it sounds like some of our records are being used by researchers, and that is important and satisfying to all of us who are associated with the board. I wanted to talk a little bit about some of the privately held records that the board acquired and are now at the National Archives, but I just want to note, I flew down from Boston today to be at the conference, and on page 3 of the Boston Globe is an interesting article which is relevant to the discussion that's been going on. I don't know if any of you saw this or if it was in the Pittsburgh papers. This is an Associated Press story. It's entitled, FBI Bullet Science Flawed, Independent Review Warns. And it goes on to say that the National Academy of Sciences has concluded that a technique the FBI has used for decades to match bullets to crimes is flawed, a position that could hand defense lawyers a new avenue of attack against the world's most famous crime lab. I'll just read one other part of the article that is related to why we're here today. It goes on to say that the science is based on the theory that bullets from the same lead batch share a common chemical fingerprint, but the study, according to those who have seen it, strongly challenges some of the assumptions and techniques that the FBI has used since around the time of John F. Kennedy's assassination. So I think that we'll be hearing more about this report, which is apparently scheduled to come out in the coming weeks. This is based on information that the Associated Press and the LA Times apparently acquired in the last day or so.
Interesting. Okay. Go ahead.
With regard to the single bullet theory, one of the areas that we found records from had to do with the Warren Commission report, and when J. Lee Rankin, the lead attorney for the Warren Commission, died, the board had contact with his son. Apparently, Attorney Rankin had a considerable amount of records that he had kept at home. They were donated after we made the inquiry with his son. They were donated and are now at the National Archives. One of the records that we found was, and apparently the Warren Commission members were given, prior to the publication of the final report, were each given a chapter or different chapters of the draft, and they were supposed to edit it. One of the records that we found in Mr. Rankin's collection was the chapter that Gerald Ford was to edit. He received a draft which said the following in describing the wounds to the president. A bullet has entered his back at a point slightly above the shoulder to the right of the spine. And in this document, you see Gerald Ford's handwritten edits. And what former President Ford changed it to say was, a bullet has entered the back of his neck at a point slightly to the right of the spine. Now, in the final report, they basically adopted what President Ford had said and described the wound in the following way. A bullet had entered the base of the back of his neck slightly to the right of the spine, virtually identical to the handwritten edits that had been made by President Ford. So this is a segue to my main point, and I won't take too much time on it, but we, led by Chairman Tunheim, put significant importance on using the authority under the law that created the Assassination Records Review Board, giving us the authority to acquire records in private hands. And as a result, we got the records from J. Lee Rankin. We acquired through associates of Clay Shaw's personal records that Shaw had kept over the years. Now, depending on what your view is on Clay Shaw, you may have different views on the value of those records. Nevertheless, the review board's task was to make the record of the assassination as rich as possible, and we included those. Other records included that we went out and found were Dave Powers, who I believe was mentioned earlier today, was a close aide to the president, was in the Secret Service limousine behind the presidential limousine, had a home movie camera and filmed during the motorcade up until shortly before the motorcade entered Dealey Plaza. That film had not been seen publicly. We made contact with Mr. Powers. He's now deceased, but he agreed to help us find the film, which was found in the bowels of the Kennedy Library in boxes of his materials that he had donated but had not been processed yet. A copy of that film is now at the JFK Assassination Record Collection at the National Archives. We also acquired records from the people in New Orleans who are important to the story. The Garrison family gave us records. The Wegman family, one of the attorneys that Clay Shaw had was Mr. Wegman, and his daughter donated records. So we made an effort to get records that were relevant and that would enrich the historical record. Obviously, we face time limitations. We always thought that there was more photographic evidence that had not been made public, that people, as Judge Tunheim would say, had an old shoebox in a closet that maybe their parents or a grandparent had kept over the years and didn't appreciate the significance of. That approach led us to acquire some outtakes from a local Dallas a local Dallas TV station, and that film and those outtakes are now part of the collection. So the question, I guess, is left: are there other records out there in private hands that are of value? I would suggest that there are many records out there. Unfortunately, we had a limited time to look for them, but the question for us, one of the many questions, is how do we get those records? What should the National Archives be doing? What should the Justice Department be doing? Because I believe they are out there, they are relevant. Thank you.
Yes. A pervasive problem in this society, the national security state, is secrecy, and the review board dealt with that and was responsible for releasing a great abundance of records that had been previously withheld. I would like Judge Tunheim to comment, if he would like, on some of the problems that some of what you learned in dealing with issues of national security with the various agencies.
Well, thank you, Jim. There were an enormous catch of records available at the agencies. We had them search for more. We started out this effort late, if you will recall. We were not appointed at the time specified by the statute. The agencies had already gone through and collected what they thought were assassination records to turn over to us, many agencies thinking that their job was just about done. When we started, we did several things that I think didn't make the agencies too happy, but it resulted in a much wider circle of a search for records, and that is, we adopted a much broader definition of assassination record than the definition that was in the statute. This caused the agencies to have to go back and look for records that could have any possible bearing on the assassination. It opened up our search and our inquiry into records on U.S. policy toward Vietnam, toward Cuba, a wide range of different areas that is not narrowly thought of as an assassination record. I think that step really has made this collection much more valuable because it opened it up much wider than simply the segregated collections that were maintained by the agencies after both their work with the Warren Commission and the House Select Committee on Assassinations. There was a penchant for secrecy. There's no question about that, and I am a firm believer that the tragedy of the assassination was compounded significantly by the secrecy that was adopted by the government. Now, at a fairly early time, many of the Warren Commission records that weren't published were released because President Johnson ordered their release. But there were still some records that were sealed when we began our work, I think about 3,000 pages or so. However, all of the unpublished records of the House Select Committee on Assassinations were sealed until 2029. That came all within our bailiwick, and we were able to release virtually everything. The other thing that we did was we insisted on a word-by-word review of the claims by the agencies that information should be protected. They wanted a document-by-document review, which would have, of course, resulted in documents being protected and other documents being released. What we did essentially was to release every document. There were some redactions, but each of the redactions had release dates, most of which have passed now, except for the release dates that are set at the end of the life of the holding up until 2017. But there's no question that secrecy was the name of the game in the intelligence agencies up until when we took over our work. And the same held true for the law enforcement agencies, who never believed that someone would have access to their files in the public realm.
I think that the review board's accomplishments were very substantial, and I know that the researchers are very grateful. There are documents that have been released, very significant documents historically for the United States, such as the Northwoods Project, the records of the PIFIAB, the President's Foreign Intelligence Advisory Board.
That was a tough battle, by the way. The President's Foreign Intelligence Advisory Board, they weren't about to release anything.
Well, it's the first time, I believe, that they ever have released anything. Yeah. And I think there's reason to question whether they ever would have released it if it had not been for the review board and the authority enjoyed by the review board. There are, however, there's some problems, some of which were highlighted in your final report. There's a continuing problem with enforcement of the review board's determinations to disclose. There are still referral documents that have not been acted upon. There is information that the review board said should be released by a date certain, and it has not been reinstated and published. What do we do about that?
Well, it's a significant problem. The JFK Records Collection Act remains in our statute books. The only thing that's missing is the review board, the enforcement mechanism, which Congress was. We were fortunate enough to get from Congress not only broad jurisdiction, but also a very broadly worded statute which allowed for a lot of openness of materials. It was written in a way that really slanted everything toward opening up records, which is what it should have done, and that's what the statute did. The problem is, what do you do right now? The Congress also compelled us to do our work in a relatively short period of time. In fact, when we were first appointed, the statute was about to run out, and fortunately there was an extension, and we got an additional extension as well, so we got 4 years to do our work. But when you're a temporary board, and you're 3 years into your 4-year existence, you start losing staff, you start losing competence, you start having people who are looking elsewhere for new jobs. I think it was a real mistake to make it limited to a specific period of time and sunset it at the end of the period of time.
That's a problem that has affected every governmental body connected with this subject. I mean, the Warren Report was on a very short time lease, apparently for political reasons. The House Select Committee only existed for 2 years. But I believe that you called attention to this problem in your final report and made a recommendation on that.
Well, we did. We tried to envision how this process would work after we were gone, and we suggested that, well, first of all, we got agencies to sign agreements to continue to enforce the statute, to continue to send materials that they found at a later time to the National Archives, to cooperate fully with the National Archives in releasing material. But we also suggested that an independent body be set up to at least oversee the process so that there could be issues addressed by that body. That was never done. That was never a follow-up that was done. And I think that's a continuing problem for the effort. The idea that we had to end the work in 4 years, that this temporary agency was not going to become permanent, was something that we all agreed with. We wanted to get this work done quickly, and there's a value to moving quickly. But at the same time, there was nothing set up for afterwards, as if the Congress believed that once we finished our work, there really would be no more issues, no more assassination records that would be found anywhere, nothing more to do with the project. Researchers could just work on the files, and that has proven not to be the case, as we all knew.
I think you can't underestimate the number of records that we don't have yet. To give one example, we only have 25% of the church committee documents that are available at the National Archives, and this was a tremendous problem
I would
for
like
me.
I would like to ask the judge about that. I think it's obvious that the review board made some threshold decision as to what of the church committee records were considered pertinent to the Kennedy assassination and what were not. Why not all of them? After all, these were assassination plots, contemporaneous. They might reveal something about persons involved who, though they were involved in entirely different assassinations, might have some relationship to the Kennedy assassination.
I just want to add one thing, Jim, and that is there are an enormous number of Oswald records in those church committee records, and they are coming from the offices of United States Customs in New Orleans, and those are all sealed, and they're not about foreign involvements.
Okay, all right.
The church committee records should all be revealed and released. There's really no reason for continued secrecy there. Our problem was that so many of the records really had no conceivable, at least on their face, relationship with the assassination of President Kennedy. We reviewed them all. We made determinations, I think about 25% or so of the records that had some possible relationship. We suggested that we would be willing to process the rest of them as well with our normal standards for intelligence-related matters. The Congress was not willing to do that. The Congress was, in fact, a difficult foe at times. In fact, today still, records of the House Un-American Activities Committee, which contain several boxes of material on Oswald, I don't think that it's very significant from a historical standpoint, but the mere fact that several boxes of material on Oswald collected by the House Un-American Activities Committee at a period of time before the assassination of President Kennedy has not been released. And the Congress has refused to release it, as I understand it, because they have a rule that says that any of the work done by the House Un-American Activities Committee is not going to be released for 50 years because it did some really bad stuff over its period of time. But that doesn't mean that the boxes on Oswald should not be released.
Sounds like a very peculiar standard for disclosure.
Well, it is a peculiar standard, but they have a House rule relative to the House Un-American Activities Committee, and Henry Hyde, who was chair of the House Judiciary Committee at the time, at first seemed to be willing to waive that, and then he turned around and decided that he wouldn't. Right about the same time they were releasing the entire Whitewater report that had been sent over to the House.
Okay. There's one issue that I and several others at this conference have raised, and that regards the statement on page 131 of the Review Board's final report regarding Admiral Berkeley's papers. It seems greatly disappointing at the least, that the Review Board did not get Admiral Berkeley's papers since he, one, apparently believed there was a conspiracy, told the House Select Committee on, his lawyer told the House Select Committee on Assassinations that he believed there was a conspiracy. He was the President's personal physician. He was President in Parkland and President in Bethesda, as no other doctor was. So those papers could be particularly important, and I wondered if you could explain why the Review Board did not take steps to get them.
Well, I agree with you completely that any materials from Berkeley are very relevant and important, and of course, for a time he possessed many of the autopsy materials that were handed off to him in his role as the White House physician. We did have subpoena power, as you recall, but we were not authorized to issue subpoenas except through the Department of Justice.
But is that a problem?
Well, that was a problem because the Department of Justice, at least for the work that they did with us, had a very high standard as to when they would permit us to use the subpoena power. And using the subpoena power on private individuals was a difficult difficult task unless there was some showing that some laws may have been broken. They were very sparse in giving us that authority. We argued with them a lot regarding certain materials. As for Berkeley's papers, both Berkeley and his attorney, his primary attorney, had passed away at that point in time. Our staff went to, or tried to be in contact with Berkeley's family. They were very difficult to reach and didn't want to cooperate with us. We did ask them if they would sign. We contacted the law firm. The law firm said they wouldn't release the materials that they had without a waiver from the family. We tried many times to get a waiver from the family. The family would not agree to sign a waiver. I don't know, Tom, if you worked on this at all in the time that you were there, but it was a very difficult problem. Berkeley's material should be made available. In fact, I think there's a strong argument that a lot of his material shouldn't have been brought home with him in the first place, as is a problem with a lot of areas of assassination records. People who worked in government, they left government, they took their records with them. And at a time when it wasn't clear that you couldn't do that. Today, that's a problem. Today, you could go after those records and get them back. That was not the case in the 60s and 70s, and that was a fundamental problem underlying our work. Tom, do you have anything to add about Berkeley?
Well, if you can remember the context, there were always issues of prioritizing. And every year that we got an extension, we had to go up to Capitol Hill and see if we were going to be funded for another year. Meanwhile, there's records that are known, that are in the federal archives, that are being processed. So it was always a difficult task to prioritize, but clearly those records should be part of the collection.
Okay. I think that now we should throw it open to questions, if people will line up at the microphones and identify yourself. And is it on? Can people hear me? The microphone's back there on.
Fiddling with it. Can you hear me now? Okay.
Yes.